A common mistake, the subject matter is one, but the two are making a mistake, and that mistake is a genuine mistake. If it's not a genuine mistake, then there is a fraud. So we assume that the two parties are not aware of that mistake. So the seller does not really check to know the model, and mistakenly gave a wrong model. And the buyer also did not check and also paid for a different model. But the subject matter is a Benz car. Nothing has changed in the subject matter, but there is a common mistake. Ignorantly, a common mistake. So what happens when they found out later that they were both making a mistake? It's not true. It's not the correct model they all thought. Then we could be void or voidable. Meaning, at the option of the person buying, he could accept it all the same and ask for maybe a damage, but not to repudiate or to reject. You cannot just reject if it is voidable. So you realize that mistakes generally, they make a contract voidable but not void. Meaning, voidable means you can do something about it, and at the option of the buyer, he could pay something as damage. But void means the whole contract is totally unacceptable, is nullified, and cannot be enforced in any court of law. So mistakes relate to a fact, not to the legal effect of a document or the transaction. And there are a lot of cases we can refer to in that respect. But the mistakes too, at times, borders on whether a contract can be enforced or not enforced. But generally, when we say a contract cannot be enforced in a competent court of jurisdiction, we are not referring to the illegality of the contracts. When they say a contract cannot be enforced, it means the contract is not illegal, but the contract writing or agreement did not follow a form which is prescribed. It did not follow a form, and therefore cannot be enforced in the court of law. It's different from is void or is voidable. But this case we say is unenforceable. For example, if a particular contract is supposed to be in writing, and you bring it in oral form, then we say you did not follow a form. Then we say that contract cannot be enforced. It doesn't mean it's illegal, only because it does not follow a procedure prescribed by law. For example, tenancy agreements, you cannot send it to the court when it's oral, because the law says when you stay in anybody's house more than 6 months, then it must be in writing. Conveyancing, any agreement, any financial transaction must be in writing. If it's oral, the court cannot enforce it. So there are a lot of employment and all that, we need to put them in writing. And I already stated that oral is accepted in agreements, not only writing. Oral is accepted, but it's advisable to put your agreements in writing because they serve as evidence when there is a problem. And if it's oral, even your witnesses might die earlier than there is a problem with the contracts. And you may not have substantial evidence to prove the oral. So it's advised that you put your contracts in writing. But if it requires that it takes a particular form, then without that form, it cannot be enforced in any court of jurisdiction. Another vitiation factor is the misrepresentation. Misrepresentation. What is it? It is a false statement of fact that is intended to induce, and in fact induces another to enter into a contract. Misrepresentation, a false statement, a lie, in which you believe and know is a lie, but use it to induce another person to enter into a contract with you. We often make that. People often do that. It's a false statement you make. You sell a car and you tell your friend, this car is a new model, it's made by BMW model, and it can take you just 2 hours to reach Accra, Kumasi to Accra, 2 hours. You see, this is a statement you know. It's not true. It's false. You believe in it. But you induce another person from taking the car because he thinks that he can take that car 2 hours to Accra. So it's a false statement. Because the person making it knew very well. When you take the case of Japan Motors Trading Company versus Randolph Motors, that case, it was held that misrepresentation is a false statement of fact that is intended to induce, and in fact induces another to enter into a contract. So before you can go to court for misrepresentation, then you must have been induced into believing it and acting on it. Not that only he said it and nothing happened, but it must have affected you first before you can bring a case under a misrepresentation. So it is untrue representation. That's a statement of fact made by one party to the contract which is not true. They had the intention to and did really influence or induce the other party to enter into the contract. And that was what the judge said. So there may be exception to that. The person making the statement never knew it exists or known of its existence, or did not allow it to affect his judgment, or was not aware of its untruth. So he might not be aware of its untruth, that what he's saying is not true. So these are the conditions under which the court will consider whether there is a misrepresentation or not. And 3 facts about misrepresentation we have to take note of. If statement is one of opinion only and not a statement of fact, even if false, there is no misrepresentation. I'm only expressing my opinion. If it's an opinion and you feel like you want to be induced into it, that is your problem. It's an opinion. If statement relates to law or legal effect rather than being a statement of fact, there is no contract. And if even the statement was false, but the one alleging misrepresentation was not aware of the statement or did not rely on it, then there is no misrepresentation because there was no inducement. So before you can talk about a misrepresentation, you have been affected by misrepresentation, then it must have really affected you. It must have induced you into taking the contract, not the other way around. What can also vitiate a contract is commonly fraud, dishonesty. And fraud is defined as a false statement made knowing or without belief in its truth or recklessly made. And fraud omnia vitiates. Fraud vitiates everything. A contract induced by fraud is not void but only voidable at the election of the party frauded, and once the party has elected to abide by the contract, being aware of the fraud, he cannot afterwards rescind it. So he's aware of the fraud or the fraudulent situation before entering. He knows it's fraud. So awareness will be applicable there. If you are aware it's fraud before you allow yourself to be induced into it, that is what we are saying. Fraud must be specifically pleaded and strictly proven. Because fraud can sometimes be presumed when consideration is woefully and shockingly being inadequate. So fraud may be implied where the consideration you have given is woefully inadequate. It can, however, be repudiated or rebutted by evidence if you have it. Okay, let's move on to incapacity. We have already talked about incapacity, and you can look at the slide already, the 30th slide of Unit 1. We talk already about incapacity, where we say one of the conditions of a valid contract is capacity. So we have capacity under this topic 2, vitiation. Incapacity can vitiate, can destroy a good contract. And we explained already what is capacity. A minor entering into a contract, a minor, a child, can destroy a contract. A drunkard making a contract with a normal person can have a problem. Or a mad person, insane person, entering into a contract with a normal person is not acceptable. There's a problem. So we, I think, exhausted that under that slide. And I'm just trying to refresh your memory about it again. So a minor or a child, when he enters into a contract, you cannot enforce it against the child, though the child can enforce it at times against the adult, but you cannot enforce it against the person. For example, when you are a seller, alcoholic drinks you sell, and a child approaches you and you sell a peteshi or some hard liquor to the child, and there is a problem